Hello, UCAR. Peter Christensen here, coming to you from the CEO's desk. So we're talking about agency. Here's we're wrapping up June, and wanted to touch on a few of the fiduciary duties you pick up as an agent. So we've talked about forming an agency agreement and the importance of getting that in writing. We've talked about not interfering with agency. We've talked about limited agency. Some of the key topics, issues that come out of agency. So let's talk a little bit about the fiduciary duties. So by rule, there are listed out some fiduciary duties. They are loyalty, obedience, full disclosure, confidentiality, reasonable care and diligence, holding safe all money, and then an accounting for that money, and then any additional duties created by an agency agreement. So pretty straightforward, but let's touch on them just briefly. So loyalty, yeah, you got to put your client's best interests in mind, right? You're loyal to that client, you advocate for them, and when might that be one that you don't, or is that conflict in a limited agency transaction, right? That one switches to neutrality. So be careful of that one, but yeah, loyalty, you're advocating for your client. And then obedience. This can be a tricky one on occasion. Basically, any lawful instruction from your client, you are supposed to help them fulfill, right? Now, I have heard instances where agents have asked me, hey, my client's asking me, they want to do something in the contract, they want to even sometimes breach the contract, they want to back out, and they say, what am I supposed to do? What's my role? I don't think it's a very good idea. Well, if it's a lawful instruction, then I think you help them. I think you help them do what they are asking you to do, but remember, your job is to advise them as well. And so I don't think there's anything wrong with you telling them, hey, there are some problems with what you're proposing to do. This may make the transaction go sideways in this way or that way, or may be detrimental to your position. Something like, I want to disclose a previous offer price that we have. You think, well, it's not technically confidential, but there are a lot of pitfalls that come with it. I would advise you not to do it, and let them make the decision. But yeah, your job is to help counsel them on what strategy to use. Confidentiality, full disclosure. I skipped full disclosure. Full disclosure, yeah, again, this one's at odds with limited agency. So you have to, that one you have to explain you can't do. But normally, yeah, if you have information that's pertinent to their transaction, you got to tell them about it. Then confidentiality. Now, this came up yesterday in a meeting where the question is just coming out, what is confidentiality? And basically, it's anything that would harm your client's bargaining position. So be careful what you're sharing without your client's permission, because confidentiality is a big deal and can be very pertinent to the transaction. Also remember that one continues after the fact. So there could be an instance where you had somebody as a client and no longer have them as a client, but you know confidential information about their bargaining position, and then they move on. And you may have a buyer who wants to buy the house you had listed previously. Well, you still owe a duty of confidentiality to that previous client. And so if it's information that's still pertinent, then you'd have to keep it confidential. So remember that one. Reasonable care and diligence. This is the grayest of all of them, right? You have to do your job well. You have to be competent. And that's where probably it gets questioned the most, is did the agent act with reasonable care and diligence? And that's, that could be everything from understanding the forms to returning phone calls and communicating with the client. So that one is probably the broadest and grayest of how do I make sure I give the proper reasonable care and diligence. But just be good at communicating, be on top of things, and know your stuff. Continue to get education, learn about the forms and contracts, the new laws coming out. And then the accounting stuff, that's all your trust stuff, and hopefully you're keeping up with that and your brokerage is keeping up with that. And then remember, you can create additional duties with your own agency agreement. So if you have a customized one and you promise extra things in it, well, you can be held to those under the state rules because you have now created an additional fiduciary duty to your client through your agency agreement. So be aware of any of those that may be in there. And you should be good to go. Hopefully this helps. As always, this is not meant as specific legal advice, just legal information only. If you need specific legal advice, contact your attorney. Happy June. Happy Agency Month. At least from here, it's Agency Month. And have a great day.